6th of April, 1952, the 300th anniversary of Jan van Riebeeck, the commander of a Dutch ship, landing in Cape Town, planting the flag and establishing a formal European presence in the southernmost part of Africa. And 300 years later, the racist government decided to have huge celebrations. The National Party that had brought in apartheid had been in office for less than 4 years, and it was a moment of triumph for them. And maybe 150, 200 people were gathered in a small town hall, not elegant and beautifully lit and soft-seated like this hall, to protest. And I was one of them. And I was with my friend Wolfie Kodesh, whom some people from the anti-apartheid movement might remember. He died a few years ago. A comrade who'd been in World War II, fighting against Hitler, come back to South Africa, decided we've got to fight racism and forms of domination wherever it is, including South Africa. And I'm sitting next to him. And we have the usual songs. He's told me there's something very special about this meeting, and Wolfie loved to have a secret, but there's no point in having a secret unless somebody else knows that you've got the secret. So he was telling me that something's going to happen. And lo and behold, a certain person whom we knew named Johnson Ngobela comes in through the back and joins the meeting. And everybody stands up and starts singing. Because Johnson Ngobela had been issued with a banning order by the South African government that prohibited him from attending any gatherings of more than 2 people anywhere in the country. And he was defying that prohibition. And that was the beginning of the Defiance of Unjust Laws campaign in South Africa, and the beginning of not using the law to achieve justice, but fighting the law to achieve justice. Those were the circumstances in which we found ourselves. And the police come and they take him away, and the songs get more fervent. And I still remember our songs used to be very, very sad songs. I was 17, a second-year law student, and the songs generally would be My boye, my boye, my boye, Africa, come back Africa, but plaintive, almost like hymns. And suddenly we're singing, Dr. Marocco, Dr. Dadu, J.B. Marks, Katani Leba Papi, volunteers, obey the orders, be ready for the action now. The body language, the movement, the emotion was different. And they're calling for volunteers. And the people are going up, it's like a revivalist meeting, and they're signing on, and the singing gets louder. And I say to Wolfie, I want to volunteer. He says, you can't. I said, why not? He says, because you're white. I said, but we're fighting racism. He said, it's got to be a black-led struggle. Black people are leading their own campaigns. I said, I'm not convinced. He said, I'll speak to the leadership. And he spoke to the leadership, and the word came through that whites could join in. Once 10,000 black people had voluntarily gone to jail to defy the unjust laws, now the time was ripe for whites, and I was leading a small group in Cape Town. There were 4 of us, and we sat down on a seat in the General Post Office marked non-whites only. We were arrested. It was my first taste of being locked up and in prison. And I still remember going into the magistrate's court, and the magistrate looks at the charge sheet and he says, I see there's a 17-year-old amongst the accused, a juvenile. Are any of his parents in court? My mother stands up and he says, I'm sending you home to your mother. And that was a terrible blow for me. I was the leader of the group, wanting to be very militant. Now, I mention this story because in a way it's the beginning of my journey, which ended up being on the Constitutional Court, but also it linked me with the volunteer-in-chief, The first person to defy the unjust laws was a certain lawyer in Johannesburg by the name of Nelson Mandela, not very well known at that stage. And it was so significant that somebody from the very small number of African professionals was now leading the campaign and volunteering to go to jail. Until then, most of the African professionals saw their role maybe as a leadership one. We have the ears of the whites, we can speak to them, don't rock the boat, don't make life difficult for us, don't be taken in by all these agitators. And now he was going to go to jail. That beautifully attired, very elegant Nelson Mandela would be the first to go to jail. We were linked. I hadn't seen him, he hadn't seen me, but we were linked by struggle. And I find it so remarkable that the anti-apartheid movement linked people all over the world who mightn't have gotten to know each other at all, simply through being joined and then getting to know one another through the struggle. Then he wasn't even in the song, Dr. Morocco, Dr. Daudu, J.B. Marx, Kutani, Leba Pipi. There was no space for Mandela at that stage because he wasn't well known. 1955, Congress of the People, some dry land on the edge of Johannesburg, 2,000 and more of us are meeting to proclaim the Freedom Charter, our vision of the South Africa we wanted to see. South Africa belongs to all who live in it, black and white together. And the police surround the gathering, many on horseback, others come marching in carrying what we call Sten guns, automatic rifles. Very, very tense moment on the second day. We are still reading out the 10 main demands, elements, chapters of our freedom as envisaged, and the police are overwhelming the occasion. If one stone had been thrown, there would have been a bloodbath. We stood up and we sang. Music and singing for us was such an integral part of our liberation movement and our sense of community and discipline and dignity and connection with each other. And so we sang and sang and sang. They took all our names, they took all the documents, and a year later, the treason trial. Can you imagine now saying that people who are calling for equality, votes for everybody, are put on trial for treason? But the argument of the state was, in apartheid South Africa, where black people didn't have the vote, the only way you could achieve equality, one person, one vote, would be through violence. And therefore, the very nature of the gathering was revolutionary and aimed at overthrowing the state. We wanted to change the state, but at that stage, the emphasis was very strongly non-violence, non-violence, non-violence. And the treason trial began, 156 accused. And in a sense, the photograph that's taken by, we had a great photographer, Eddie Weinberg, who'd been subjected to banning orders, restrictions. He couldn't do trade union work that he'd been doing. He became a photographer, and he managed to photograph 156 people. It's a famous picture. And there you see the nation, black, white, brown, young, old, male, female, and standing right in the center, taller than anybody else, better dressed than anybody else, was Nelson Mandela. And he was one of about 6 lawyers who were put on trial. It was so boring. It dragged on and on and on. And in the end, ridicule became one of the mechanisms of legal defense. It reached the stage, even when it was dragging on, where the defense counsel, and we had some of the best lawyers in South Africa, now giving up their ordinary, lucrative commercial work to defend the accused in that case, asking on a Wednesday afternoon for the court to adjourn so that the accused could go out into the streets of Pretoria with tins collecting money for the Treason Trial Defence Fund. Now, I've never heard of people on trial for treason collecting money in the streets of the city. Those are the contradictions of South Africa. In any event, the 6 lawyers are bored, and they decide they're going to take part in the proceedings, not simply as accused number 23, but as defense counsel representing themselves. And that was when one person began to emerge as somehow peculiarly adept to the forensic setting. with a presence and eloquence, a capacity to focus, to speak with firmness and vigor, but in a stylish and respectful way, respectful of the situation. That was Nelson Mandela. So that was when Nelson Mandela began to become Nelson Mandela, and not just be another one of hundreds and hundreds of respected and admirable figures in a very broadly based movement. The trial dragged on from 1956. Eventually it collapsed in 1961. But already the Sharpeville massacre had taken place, 1960. 69 people going to the police station saying, we're not going to carry a pass. The police, I don't know if they panicked or whatever it was, but they fired into the crowd. There happened to be television cameras on the spot. The world saw 69 people dead, lying dead on the ground, mostly shot in the back. How would the South African government react? Acknowledge Africa was changing, the world was changing, white domination was no longer acceptable as an overt principle of government and statecraft? Or, and the government decided, the policy of granite. We don't give in. Whites will continue to rule and dominate white South Africa. Blacks will have their rights in black South Africa. It just so happened by a peculiar accident of history that whites happened to own, by law, 87% of the surface area of the country. The black population, 13% of scattered rural homelands, impoverished rural areas where none of the mines, the ports, the airports, the manufacturing industry, none of those existed there. So this was now a proclamation to the world, white domination continues. And the ANC is banned, and the Pan-Africanist Congress is banned, and the Communist Party had already been banned. Newspapers are banned. Meetings are banned. Individuals are banned. We couldn't even protest anymore. Before, at least in the 50s, we could say this is an unjust society, we want change. We could mobilize, subject to various restrictions. Now we couldn't even do that. And Nelson Mandela issued a statement, it's now submit or fight. 1961, South Africa becomes a republic. This was the dream of Afrikaner nationalists after the Anglo-Boer War, the conquest by the British of the Boer republics. And South Africa declares itself a republic. It's compelled to withdraw from the Commonwealth because of its racist policies. And Nelson Mandela, who's now gone underground to carry on with the struggle, issues a statement saying, most of us would probably, in the African community, support a republic in South Africa, but we haven't been consulted. We are people of South Africa, the majority. And the status of our country is being changed without us being involved at all. And he called for a national convention, bringing together representatives of all South Africans to draft a new constitution based on democratic principles. Sometimes it's a bit upsetting in hearing the biographies of Mandela, where he's reduced simply to this person who somehow didn't have an earlier life, but spent 27 years in jail, came out with no bitterness in his heart, and led the South Africans to a peaceful revolution and transformation. It trivializes him. He was asking for a national convention on behalf of the ANC and other organizations already in 1961. He didn't create that policy. It wasn't a personal thing. It was the product of a whole culture of resistance and opposition. And he was a revolutionary. He went underground, he left the country, he got military training. The ANC decided, we've reached the stage now where we can't even protest anymore, and armed resistance must be part of our liberation struggle. And he was now the commander-in-chief, volunteer number 1. He comes back into the country. He's eventually captured, strong evidence that the CIA, in fact, had intelligence which they gave to the South African government. They trapped him. He was being driven by... In fact, he was driving a car with one of our comrades, Cecil Williams, a play director, a theatre person, pretending to be an important white businessman so that Mandela could travel around the country doing underground work as his driver. At that stage, the authorities didn't know everything that he'd done, put him on trial for leaving the country unlawfully. And now he represents himself in the court. And again, with that special quality that he had, he asks the magistrate to recuse himself. But he does so in a very dignified way, saying, Your Worship, I have no personal complaint with the manner in which you are conducting this trial. It's not a personal matter. What I'm saying is not aimed at you. But I feel that I am a black person in a white man's court, and I shouldn't feel that. And I feel that in South Africa, and he slowly moved up to it, it's the guilty who drag the innocent before the courts. And therefore I refuse to recognize the authority of yourself with no personal disrespect intended and meant to hear the matter. It was a very beautiful speech, very eloquently done. He got the maximum sentence, and I heard years afterwards the magistrate, in fact, said he went to his office afterwards. The magistrate told somebody, this is like 30, 40 years later, and he said he cried. He was fulfilling what he regarded as his duty at the time, but he was deeply moved by the statement that was made. So Mandela disappears from the scene until a year or two later, he appears with the Rivonia accused. I might mention in my own case, I'd met him just once in that last period when he was underground. It was in Johannesburg, round about 1962, a couple of months before he was arrested. And we were literally in the underground. I was driven around and around and taken somewhere, and we went to somebody's basement. And there might have been 15 or 20 of us, very difficult circumstances, very anxious. The police might come, we'd spend hundreds of years in jail between us, and then slight commotion, and then in comes down the steps this tall figure of Nelson Mandela. And I still remember that wonderful smile that he had, almost with a touch of bravado, that little special quality that gave us a certain extra sense of confidence. Now he's on trial amongst the Rivonia accused. Not long afterwards, I'm thrown into solitary confinement. I don't even know what's happening to any of the accused. I think they wanted me to be a witness against some of them. 168 days, that's another story. Eventually, the Rivonia trial nears its conclusion. And now Nelson Mandela decides to make a statement from the dock. I don't know if you have a similar procedure here. People who are defendants in a criminal case can refuse to say anything at all. They can go into the dock and state their defense, in which case they are subject to cross-examination, or they can simply make a statement they can go into the witness box and make that statement, or they can make a statement from the dock where they're standing. The advantage of making a statement from the dock is that you're not cross-examined. You just make the statement. The disadvantage is it carries much less weight. You're making these points, you're not giving the prosecution a chance to question you. So in terms of our legal theory, legal practice, it carries less weight. And some of the other accused went into the dock, they were cross-examined, but he decided he wanted to make a complete statement, the statement from the dock. And the statement ended up, after explaining how it is that he'd become involved having believed for many years in a peaceful resolution of South African situation, growing up in a very democratic ethos in traditional African society, where the progressive traditional leaders consulted with the community, represented the whole community, joining the ANC, struggling to get votes for everybody, and finally taking the decision that we have to resort to arms. And he ended up with the famous statement, "I have spent my life fighting against white domination and fighting against black domination. I believe in equality for all. These are the ideals for which I have lived, and these are the ideals for which I'm prepared to die." And his counsel, George Bezos, said, "Nelson, that's a little bit provocative. You're almost challenging the judge to sentence you to death. And not just you, but all the others. Can't you soften it a little bit?" And in the film that's been made of my life, the filmmakers happened to get the actual text with Mandela's handwriting on it, where he puts in the words, "These are the ideals which, if needs be," written in, "I'm prepared to die." He disappeared after that for 27 years. These were the last words South Africans heard of Nelson Mandela for 27 years. And yet silence can be very powerful. Knowing that this person with such stature, representing everything that is good and decent in our society, together with his colleagues who are also in prison, my friend and colleague from our youth movement, Dennis Goldberg, separated by the logic of apartheid, even although he was condemned in the same trial by the same judge, even the traitors had to be separated on grounds of race to Pretoria prison. But silence became a huge mobilizing factor. And in a way, the potency of Mandela was greater when he was locked up and gagged than at almost any other time in his life. And people started speaking out. And Oliver Tambo, his law partner, who'd been sent out of the country by the ANC to mobilize international support for our struggle, decided you can't just ask the world to demand the release of the Rivonia 11. It's too abstract, the Rivonia accused. And he decided we put the emphasis very much on Nelson Mandela, because the world could respond to an individual, a name who represented the culture of a whole community in struggle. And I still remember so well in London, 1988, and I'm recovering from the bomb that blew me up in Mozambique. And there's going to be a concert at Wembley. I've never been to a pop concert. I'm still quite fragile. I'm wondering, what do you do? Do you stand up and say, yay, yay, yay? In the end, the arrangements, the logistics got too difficult. I watched it on television. It was so wonderful. 70,000 young people at a time when people were saying, oh, the youth of today. I think my whole life I've been hearing people saying, oh, the youth of today, over decades. And that was a time when the youth of today in England was seen as football hooligans, uninterested in anything in the world, and 70,000 packed out Wembley. Free Nelson Mandela! And everybody stood up. So that voice, in a sense, of the silenced person became magnified, it became enormous. It became a huge factor which led to the release of Nelson Mandela, supporting the divestment campaigns, which I think got some of the earliest moves here by trade unionists in Ireland. Little shoots that seem to be so innocuous and useless when they begin, then suddenly become enormous over years and years and years of mobilization. And Mandela, 1990, is released. And a whole new chapter starts. Until then, it's resisting the law, fighting the law, transforming the law, and at the same time still using what spaces were available within the law to defend people, to prepare for the future. Legal Resources Centre, set up by Arthur Chaskelson, who became Chief Justice later on, giving up a very, very lucrative legal practice to become full-time, doing public interest law only, even under conditions of apartheid. Winning little cases here and there, but also training a new generation of lawyers with a different approach to what law can mean for people who felt it was obnoxious practicing law in racist South Africa, and were worried that law favored the rich and the advantaged all over the world, and somehow there was something inside them that was dissatisfied with becoming a party to that. And now they were given the opportunity to use their energy and their idealism to bring about transformation and change in their country, even under apartheid. The negotiations start. It's a whole different period that requires a different form of presentation. But I fast forward to February the 15th, 1995, in another small room, maybe the whole room as big as the platform and up to the front row here. And I'm sitting up on a raised platform with the ceiling much lower than this. And I'm one of 11 people wearing green robes. Nelson Mandela gets to his feet. The place is jam-packed. The last time I stood up in court, he says, was to find out if I was going to be hanged. Today I rise to inaugurate South Africa's first constitutional court. It was such a special day, not only for those of us who were sworn in, but for the country. And we felt so special that Nelson Mandela should be the person, as president now, democratically chosen president, chosen by Parliament to be president of the country, the person presiding on that occasion. And some of us had worked in the underground, myself with Nelson Mandela, Arthur Chaskelson had been amongst his legal counsel at the Rivonia trial. Others had been judges under apartheid, but dignified, decent judges using what tiny space was available to defend rights as much as they could. It was very, very limited. A small minority, but did a lot to rescue the reputation of the judiciary in those circumstances. Others, like Pius Langa, the head of the National Association of Democratic Lawyers, representing mainly the relatively small number of black lawyers in South Africa, fighting not just for more work and better training for lawyers, but fighting for a just legal system and a new constitution in the country. And we sworn in. Yvonne Mokgoro, who speaks so beautifully in the film about me, and you see her taking the oath in Setswana, and she's saying, imagine what it's like. Who, me? I was expected to keep quiet, to shut up, and now I'm on the highest court in the land. So it's all in front of Mandela representing everything. And how does a court show its gratitude to a great leader like that? 6 months later, we struck down as unconstitutional 2 important proclamations by Nelson Mandela. Now that's gratitude for you. And they were very progressive proclamations. They dealt with the first democratic local government elections ever in South Africa. We'd had the national elections, many of you would have seen on television, the long lines, black and white together. But this was now going to be elections for local government, as important, sometimes even more important than the national elections. And Parliament noticed it had very little time left to get the laws passed in the ordinary way, and said, in effect, Mr. President, will you adopt the laws that we need to structure the elections, to make sure the vote is free, the ballot is secret, that people are appointed and paid, that you have all the restrictions on where you can canvass and where you can put up your posters and all the things that elections need. and he issued the two proclamations, having been requested and required by Parliament to do so. They were challenged by members of the opposition in the Western Cape, so it had a provincial versus national government dimension and a national party versus ANC dimension as well. And we upheld the challenge. Not exactly on the grounds that had been advanced, but on the basis that Parliament had no authority to entrust major lawmaking to the President, to the executive. A very profound constitutional principle. The Constitution required that Parliament adopt the laws and set procedures that lay down, and the executive fulfill the laws, administer the country, and didn't allow Parliament to abdicate its lawmaking authority to hand it over to the presidency. And I must say, when I heard my colleagues, I remembered the example that we were told about of Hitler. 1930, the Reichstag gave Hitler lawmaking authority, and that was the end of Parliament. So quite a profound principle was involved. And we're wondering now, how will Mandela react? He appointed us, mainly from lists given to him by the Judicial Service Commission. He'd been in jail for 27 years. Some of us had been sitting on the bench in that time. What effrontery, what disrespect. In any event, we were curious, and we watched on television. He went onto TV quite soon, and he said, when I adopted those proclamations, I acted on legal advice, which I accept at the time as being correct. I now accept that that advice was incorrect. It's a bit hard to single out my friend Fink Haysom, who had actually been his legal advisor at the time. And he said, I, as president, should be the first to accept the decision of the Constitutional Court interpreting our Constitution. Now, for me, that was a moment, a day, as important in South Africa as the day we all voted as equals for the first time. Because now we are not just a democracy, we're a constitutional democracy. And when the minister spoke about that sense of ownership and freedom in South Africa, that's part of it. Democracy isn't just voting every 5 years, although that is central to any democratic project. It's central, but it's not comprehensive enough. You need an open society, the openness, and you need the sense of the Constitution controlling all exercises of public power. And once Nelson Mandela had accepted that, then it became easy for the town clerk and the postmaster general and the minister of justice, whoever it might be, whose actions and laws that they had adopted being struck down, to say it's not personal. It's not those 11 individuals up on the court who've got it in for me. It is applying the Constitution. That's the context now in South Africa in which public interest law takes its rightful and honored place in our legal system. We have massive, huge problems, mostly inherited from the structures of apartheid and the injustices associated with racial oppression. But not all of them, and some we've magnified, we've made worse for ourselves. I sometimes say we've shot ourselves in the foot so often we've run out of feet to shoot ourselves in. So we can't blame it all on the previous regime. But we are free in that sense. As the minister said, we own our country, we can speak out. And we can use the courts, and litigation can play an important role. Our Constitution expressly gives wide standing for public interest litigation. You don't have to bring a case on the very narrow case and controversy basis that I am a person who's being directly affected by government action. So we don't spend a lot of time in that sense. There has to be, the shoe has to pinch somewhere. We don't give simply free legal advice on abstract issues. The issues have to be real, but the people bringing the case can show that they're doing so in the public interest. That became a very important matter. Then the second aspect that turned out to be important was the existence of the Legal Resources Centre and a number of other public interest legal bodies. And they had already trained in the apartheid era. The very first case we had dealt with the constitutionality of capital punishment. 400 people on death row. South Africa used to hang 100 people every year. We even had a gallows with 6 nooses to make the execution more cost efficient. Is that compatible with our new constitutional order? The negotiators couldn't agree. ANC totally opposed to capital punishment. The old government, for me it's quite paradoxical, the black liberation movement that's supposed to be barbaric, totally opposed to capital punishment. The white party, expressly white party, that's supposed to be civilized, demanding capital punishment. We couldn't agree. We couldn't delay elections because we couldn't agree on that. So it was agreed to leave the issue to the Constitutional Court to decide on an open textured Bill of Rights that didn't expressly authorize capital punishment and didn't expressly forbid it. Mozambique and Namibia expressly forbid capital punishment. We left it open. Legal Resources Centre brought argument to us. Amnesty International provided materials. We got other materials from all over the world, beautifully crafted and presented arguments. Nelson Mandela sent his lawyer George Bezos on behalf of government to ask us to strike down capital punishment, but the state was represented by people arguing in favor of capital punishment so that we could hear both sides of the argument. Unanimously, we decided capital punishment was inconsistent with the humane society envisaged by our new constitution. Corporal punishment, again, Legal Resources Centre presenting the case. We found that having strong NGOs and social movement bodies assisted us enormously up on the bench. Because if people just come to court, they're filled with rage and anger, understandable, because life is hard and bitter, but it's inchoate, it's all over the place. It's not feeding into the kinds of legal, I'd call it an enlarged legal debate that you need in these issues. It's hard to get to pinpoint the manner in which you can function. The technology, if you like, of the law requires a certain coherence, and that's what we were getting now. Enlarging our vision, but feeding into long accepted principles of law and legality, enabling us to develop our jurisprudence on strong foundations. The more difficult the issue, the more divisive it was in terms of public opinion, the more important it is to have a sound foundation and platform for the way you develop and evolve the law. Corporal punishment, we had juvenile whipping, ordered by the courts. When I was in prison at one stage, my jail was attached, the lockup, to the back of the court, and every afternoon at about 4:30 I would hear the screaming, and I would just close my eyes, and I had 2 arms then so I could block both my ears to hear that terrible, terrible screaming, and to imagine that somehow that's making the world better and teaching people a lesson. The only lesson it's teaching people is force rules, force dominates, that if you can use pain to achieve your objectives, go ahead and do it. We struck down corporal punishment as being unconstitutional. The idea of deliberately inflicting pain to make somebody a better person was anathema to us. When we had somebody charged with, wanted in America for having exploded a bomb that killed many people at the American embassy in Dar es Salaam, turned out to be an Al-Qaeda operative, came secretly to South Africa, is working as a pastry chef, very, very quiet, very calm. He suddenly disappears. The owner of the confectionery wants to know what's going on, comes to court. The court says there's nothing we can do. He lied. He came illegally into the country. He's been deported, and he was shipped off in an FBI plane to America. We said that's not appropriate, the way it was done. Of course he must stand trial. But a similar co-accused of his in Germany wasn't just extradited, wasn't just handed over, and there wasn't rendition, that's the term that was used, we came across for the first time. A proper application was made for extradition, and he was entitled to legal defense. In this case, the argument was he hadn't been entitled to a lawyer, and we said the more serious the case against you, the more important it is that you have legal defense, and most important of all, a substantive level, we should have gotten assurance from the American government that he would not be executed if found guilty. And the German co-accused, the one in Germany, was given that assurance. So that's Germany. We are just bottom of Africa, struggling so hard to develop rule of law principles, and a country working with our people who are so excited, working with the FBI, decides to ship him out through the back door. And we issued a very strong judgment. It was too late to get him back now, but we sent a copy of our judgment to the trial judge who was hearing the matter, indicating that he should not have been allowed by our officials to go out of the country unless he'd been given an assurance that he would not be executed. And again, I think it was the Legal Resources Center that took up that case, a tricky case, a sensitive case, a very important case for establishing certain fundamental norms in our society. We had a number of other issues dealing with gender. In some cases, it was same-sex passion and desire, striking down the laws that sent people to jail for sodomy. Later on, it was related to immigration, later on to same-sex marriages. And again, we had NGOs assisting the court. We had people some from the Catholic religious bodies opposing when it came to same-sex marriages. And of course, they were important NGOs, and they had an important contribution to make. But it was very helpful to us sitting up on the court to get well-prepared arguments. More controversial the issue, the more important it is to get advocates presenting solidly research material and presenting arguments that are thoughtful. Patriarchy. I once wrote, and Catherine McKinnon, who didn't often quote men in her book, cited this one, the statement, the only truly non-racial institution in South Africa is patriarchy. We found it amongst white men and black men and brown men. It was leapt across all the other divisions in our society. And it becomes a very live issue in all sorts of litigation contexts. And we have a women's legal center that again brought a number of cases, often because patriarchy presents itself in such an elusive, indirect way. It's got a cultural kind of dimension that makes it appear as though it's kind of natural and normal. It required very sophisticated argument and a strong response, which I hope we were able to come with on our court. One of the cases dealt with customary law. Can a tribal community choose to have a woman as their traditional leader? She said 5 minutes 3 minutes ago, so I managed to gain an extra 3 minutes. And the argument was that under traditional law, the system of male succession applies, and customary law is recognized in our Constitution, subject to the Constitution, but we must recognize the traditional values. Our court said no. Customary law is living customary law. It evolves. Women now in the rural communities are looking after the homes. The men are often away. They build the homes. They look after the cattle. They do everything. Women now they have ATMs. They go to ATMs to draw money. They're earning. Some are sitting up on the bench. And it's ridiculous to apply the systems that made a lot of sense in a pastoral, rural kind of community to modern-day society. Again, we had NGOs bringing very important material, advancing important arguments to us. So that's another whole area where it wasn't a question, some people see it, some of maybe of my more conservative colleagues might have seen it as these busybody, pesky people coming to court and raising all sorts of issues to try and upset traditional laws we understand. On the contrary, it was helping to bring the law in line with our new constitutional vision and helping to humanize a country that was grossly divided with all sorts of sectors of institutionalized or systemic inhumanity. It was helping to develop that and was helping to create a rich jurisprudence, prisoners having the right to vote. Human rights, Lawyers for Human Rights brought that case, and I was asked to write the judgment. And we said that it wasn't open to the Independent Electoral Commission to say it's too expensive and time-consuming to give prisoners onto the voters' roll. We said only Parliament can limit the right to vote, and then Parliament must justify it in ways that hadn't been done in that case. So prisoners in South Africa will be voting on May the 7th. I was very thrilled to see the Canadian Supreme Court quoting a statement I made that the right to vote in South Africa was so central. It wasn't just important for democracy. It was the sign of equality. It was indicating in a very divided society that in the eyes of the Constitution, quite literally everybody counts. And they picked up that phrase, quite literally everybody counts. It had that meaning in terms of human dignity that went beyond simply getting a democratic outcome. The final case I'll mention where NGO made a big difference was the BioWatch case, and that was on environmental justice. And the issue came to us in a curious way. It was only on the question of costs. BioWatch wanted to get information about genetically modified goods, plants, organisms, and went to the Ministry of Agriculture to demand information. And Monsanto, it was about Monsanto and the activities of Monsanto. And Monsanto came to court and opposed, and the judge hearing the matter granted some of the requests that were made by BioWatch, but said, you just threw the whole book. You asked for too much, and I'm awarding a costs order in favor of Monsanto against you. To say there was a tremor, a tsunami of anxiety in the NGO community would be a gross understatement, because if they're going to be mulcted with cost orders every case they lose, they'll go out of business very quickly. The donors who are supporting them will say, sorry, we're not going to send you money that's going to go to Monsanto's lawyers. And the case came on appeal to us. There were two difficulties that were adverted to by counsel for Monsanto with interfering. One is there was a rule in the Gauteng High Court that said you can't note an appeal only on the question of costs. And that was because lawyers were using that to delay the enforcement of judgments. They would argue against the cost order, and it would give them an extra few months, and then they would settle on the basis of, okay, we'll pay you, but you must reduce the amount that we're going to pay you. It was being abused. So there was that rule. We said as a court, we're not bound by that rule. We're the constitutional court, it's a different issue. The other issue is a very strong principle, I guess it's the same here, that costs awards are very much in the discretion of the trial judge, who hears the matter, gets the overall sense, and you don't want to upset it on appeal unless there's been a clear misdirection. But we said in this case there was a clear misdirection because the judge didn't take account of the fact that BioWatch was a public interest legal body, and not because you have to be softer on public interest bodies than anybody else. It's not the body that is the litigant that matters, it's the nature of the litigation. This was litigation in the public interest. It dealt with asserting a fundamental right under the Constitution. We have environmental rights in our Constitution, and a fundamental right of access to information, because we also have that in our Constitution. And so we said that we're setting aside the order, and generally our courts, and I'll end with this, our courts have taken the position, starting with the Constitutional Court, to go away from the ordinary principle that the loser pays, unless there are good reasons for not getting the loser in litigation to pay, to say that in constitutional litigation, the courts should facilitate and encourage people to bring their constitutional claims to court, rather than fighting it out in the streets, wherever it might be. We want to encourage that. And so it means most constitutional cases involve the state as one of the parties. If the state wins the case, then each party pays its own costs. If the state loses, then the state pays the costs of the litigant. But we emphasize it's the nature of the litigation, not the nature of the litigant, that counts. Unless the case being brought is clearly trivial and involves almost an abuse of the process of court, then you might award costs. But short of that, if there's a serious issue being raised, then the award of costs will take account of the fact that the litigation is in the public interest generally, that people are pursuing their fundamental rights. People should be encouraged to come to court to sue their fundamental rights. And I had my 15 minutes of fame in the PILA South African community when that judgment came out. It was a huge relief, not only to BioWatch, but to all people doing public interest law. I'm very thrilled to be at this conference today. I'm very happy to be here in Ireland, where, as I've said before, you can use the word freedom, and you're not like sometimes in London people say, how do you define freedom? There's some things you feel that's part of your culture, your temperament of who you are, the way you see the world, and I feel that very, very strongly in Ireland, and I was very thrilled to be invited here, and I wish the rest of the conference every success. Thank you.